wrap up the presentation part of the evening and take us down to Q&A, I'm thrilled to welcome Quattrone Center affiliated faculty member and Penn Law faculty member, criminal law professor David Rudovsky. Professor Rudovsky is one of the nation's leading civil rights and criminal defense attorneys. In addition to being a senior fellow at Penn Law and teaching here, he practices public interest law with the firm of Karras, Rudovsky, Messing, and Feinberg. He became a senior fellow at the law school here in 1988 and teaches courses in criminal law, constitutional criminal procedure, and evidence. He's a co-author of Police Misconduct, Law and Litigation, and the Law of Arrest, Search and Seizure in Pennsylvania. His awards include a MacArthur Foundation Fellowship and an award for accomplishment in civil rights law and criminal justice, the ACLU Civil Liberties Award, and most recently, his 5th Harvey Levin Award for Excellence in Teaching at the law school. He also won a University of Pennsylvania Lindbeck Award for Teaching Excellence in 1996. Most recently, he and Quattrone Center affiliated faculty member David Abrams released a report in which they analyzed the data on stop and frisk in Philadelphia, the case where Dean Epps is the court's monitor. And he's been an extraordinary mentor and advisor to me as we've gotten the center up and running. To talk about what we do in the face of all of these Brady violations, and actually, I think, Sydney, to address a point that you made, we kind of do have a rule for what happens when we have intentional misconduct, and it hasn't worked. Professor?
Thanks. Quite a panel. Hard to go clean up, but those 3 good hitters first, I'll tell you that. But I want to pick up on the theme that Sydney left off with, which I think is the most important thing to think about in terms of Brady violations, and that's accountability. Because you sit back and you think, okay, well, we'll have some cases with some rogue prosecutors and they'll do the wrong thing, and that'll happen in any profession, and maybe you really can't control that. People will do bad things deliberately, and so we'll maybe have to live with some of that. But whether we call it an epidemic, as Judge Kaczynski called it, or whether we look at the data, which shows that there are numerous violations of Brady, whether we look at exonerations and find out that 25% of the exonerations were included Brady violations, when we look at conviction rates and reversal rates, and we see courts repeatedly talking about the failure of the prosecutor to turn over exculpatory evidence, you sit back and think, well, wait a minute. We've had this rule for 50 years as a constitutional doctrine. As John alludes to, we have a rule of professional responsibility, 3.8, which says virtually the same thing. We didn't even need Brady. 3.8 of the rules of professional responsibility in virtually every jurisdiction specifically prescribes the duty of a prosecutor to, quote, make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense. So we have a constitutional doctrine, we have a professional responsibility as prosecutors to disclose it, and yet we still see, to some extent, increasing numbers of cases in which there's clear violations of the Brady rule and obviously of the professional rule itself. Why is that? My basic submission is its lack of accountability, and somewhat ironic for prosecutors who live by the notion of accountability, right? That's what the whole system of prosecution is built on. We hold you accountable when you do something wrong, and we won't have a fair or a decent or a safe society unless people pay a penalty when they do something wrong. We can believe that or not, but for prosecutors, that's their mantra. That's what they live by. And yet we have built a system, and it's not just the prosecutors who built this. They've supported it, but complicit in that construct have been courts, have been bar associations, and have been judges who, while they talk the good game about Brady disclosure requirements, fail to back it up with any meaningful remedies. And so one question is, what's the substantive rule? Do we get the rule right? Is the rule broad enough? Is the scope right? But much more important is, are there remedies that are going to make sure the rule is followed? Let me talk about the rule for 1 second, and one major flaw in the rule, which the Supreme Court has created and doesn't seem willing to back off of. Brady said, disclose all evidence that's exculpatory, including impeachment, a very broad rule. But then, as John mentioned in his introduction, we've spent 50 years dealing with this additional term, but only if it's material. Well, that's an interesting concept. I'm a prosecutor. I'm looking at my file. I think the guy's dead guilty. I've got 4 witnesses who identify him. I've got a confession. I may have some videotape. And in my file is a statement from somebody else who says, well, he was with me someplace else at the time. I think it's junk. I don't believe it. And I'm thinking, I could be thinking 2 things. Well, it's clearly exculpatory under Brady. I've got to turn it over. Let's see what happens at trial. If it's that weak, nothing will happen. But I'm a little concerned, well, maybe, this is going to punch a hole in my case, or there's some impeachment material about one of my witnesses, even though I'm sure the person's guilty. And so now the Supreme Court has told me I only have to turn over that evidence if, after conviction, a court would say that that was material, right? That there's a reasonable likelihood that if that evidence had been turned over, we'd have a different result. Well, now I've got a safe harbor. I look at that evidence and I can say, that won't make any difference. I don't have to turn that over because in my professional opinion, even though it's, quote, exculpatory, even though it may be impeachment, I think the evidence is so overwhelming it's simply not material. And so what the Supreme Court has done is twofold. They've said to prosecutors, it's your decision and your decision alone in determining what is exculpatory and what is not. And in making that determination, you can be assured that if you don't turn it over, but if your case is strong enough, we won't reverse the conviction. We won't find a Brady violation. So there is an initial flaw in the doctrine. We all think this doctrine is very broad and all-inclusive. It's not. It actually means, and when you look at appellate decisions on appeal, that gets reaffirmed. The number of cases in which appellate courts say, yes, there was a Brady violation in the sense that exculpatory and impeachment material was not turned over, there are hundreds and thousands of those cases. When you look at the reversal rate in those cases, you find it's 5%, 7%, 8%, something like that. I don't have the exact numbers, but it is a very, very low number. Why is that? Because the appellate court now with a conviction says, well, we're pretty sure he's guilty. You didn't turn over this eyewitness, you didn't turn over this impeachment, you didn't turn over the fact that the informer, maybe lied in a different case, but we don't think that would have made a difference. And so, yes, there was a violation, but no remedy. And the Supreme Court has deliberately done that. They refused to back off that doctrine. And so even within the substantive rule, we've got a significant limitation. Beyond that, the court has said, but then you can think, well, all right, so maybe if that's the rule and we don't have a remedy of reversal of convictions, which would be the most direct impact on prosecutors, they would have to retry the case and maybe they'd think twice about not turning over exculpatory information in the beginning. Maybe there are other remedies than we often hear. Well, it's not the only remedy we have. Perhaps once we find that there has been not disclosure, we should be able to sue the prosecutor. Take the case where the prosecutor in the really rogue case, right, deliberately doesn't turn over exculpatory evidence. We have absolute proof of it. The person's been exonerated, he's been acquitted, there's DNA evidence, we know it happens, and we know the prosecutor's not turned over that information. Well, okay, the person's out of jail, that's good. Not even a retrial. But then we've got to think, well, there's still some culpability there, right? That person spent 5 years, 10 years, 20 years in prison because a prosecutor deliberately, intentionally didn't turn over. We're not talking about making a misjudgment as to what it is or wasn't. It's not a question, did you check with that agency and that police officer? We're not talking about that kind of extraordinary effort. I have it. I know it would make a difference. I'm not going to turn it over because I think he's guilty or I have some other reason not to turn it over. So we would think in our system, okay, you'd have a civil rights suit, right? You can sue police officers if they do that. You can sue other officials if they do that. What does the Supreme Court say? No, absolute immunity. They create out of whole cloth, really, a doctrine of absolute immunity, saying, well, when the Civil Rights Act was passed in 1868, there was generally prosecutorial immunity. Wrong. We didn't even have professional prosecutors at the time. There was no such thing as a prosecutorial immunity, but they basically created that doctrine and said, well, it's too dicey. If you can sue prosecutors, then every defendant's going to sue a prosecutor and, it will be impossible to winnow out the cases where there really is a good claim and where there's not. And so we give prosecutors absolute immunity, even if, as I say, in the hypothetical case, I say, everybody agrees the prosecutor did it deliberately. Somebody spent 10 years in prison, the person's innocent, and it was done, right, to get a wrongful conviction. Simply no civil remedy. Well, the court says we really don't need a civil remedy because, after all, they could be criminally prosecuted, right? I mean, if they did it that badly, there could be criminal prosecutions. Well, tell me how many criminal prosecutions there have been of prosecutors over the years. When we see it happen, as in Texas, right, fairly recently, the Innocence Project in Texas, Barry Scheck was involved in it, was able to prosecute a former prosecutor. I think he got a very short sentence of 10 days or a couple of weeks, right? But it makes it right.
Michael's prosecutor got 5 days.
So it makes its impact, but the number of prosecutions of prosecutors, put aside police officers, of prosecutors, almost impossible. Who's going to prosecute the prosecutor, right? Well, then you say, and the court said, well, but there also can be internal discipline. I mean, surely a prosecutor's office that finds out that one of its fellow prosecutors has deliberately not followed the Brady rule, has withheld exculpatory evidence, which they know would have resulted in a different verdict. Surely the prosecutor's office, or if not the prosecutor's office, the bar in that state, remember we've got a rule of professional responsibility, the bar in that state upon a complaint, right, will take action. And so we really don't need this civil remedy because there are other remedies. It's kind of, it's a game of, it's the shell game, I call it, right? So we really don't need a civil rights action because we've got these other remedies. When we look at the other remedies, they don't work because you've got some other possibility, right? You can get your conviction reversed on appeal. That's really enough. So when you step back and you think, why is it that we have, whether you call it an epidemic or just a large number of Brady violations? I think it's not only because we've got prosecutor officers that are not doing the right thing and prosecutors who occasionally will do it deliberately, but we have built into this system all these safe harbors for prosecutors. And there's very little chance, if you're thinking as a prosecutor, should I take a chance? There's no reason not to. The worst that can happen, even if we find the exculpatory evidence, and remember, we're talking about the tip of an iceberg. The cases in which we find it, even though there are numerous, is simply the tip of the iceberg. There are thousands of other cases where we'll never know. Buried in the files is exculpatory evidence. I mean, we'll never know that because we don't have the open disclosure and we don't have any means of doing it. So, what's the remedy for that? I mean, given 50 years of infutility, right? Given the protections that the system has built for prosecutors in this situation, even though they like to trumpet Brady. Brady becomes, right, I mean, the 50th anniversary of Brady, look what a great system we have. We force prosecutors to do something defense lawyers don't have to do, right? We have this asymmetrical world, and we really require prosecutors to play fairly. There are some pretty easy fixes, actually. Think about just the proposal that prosecutors, even if you don't go to open file discovery, which is probably what we ought to be doing, if there's a Brady rule, we've dealt with this problem now in civil discovery. Since the advent of e-discovery, electronic discovery, courts have had to think about, well, we've got this massive amount of information out there that civil litigants have, and that when a civil case starts, we know there's a lot of electronic data out there. How are we going to take that into account when we know there's got to be disclosure and discovery and transfer of documents back and forth? Courts have developed protocols, which is kind of this rolling discovery, right? Each side has to list everything they have. They have to preserve all that information. They then have to disclose it as a period of discovery unfolds. No reason we can't do that the same on the criminal side. You have it. You have to certify that you've done it. You can build that paper trail. Will there be prosecutors who continue to hide it? Sure. Are there civil lawyers who do it? Probably do so, but we're going to reduce the number. And if we make this part of a regular process, a protocol, whether it's open file discovery or simply a protocol that requires the prosecuting attorney regularly to review all the information in her file, to consult with all the agents in the case who may have something about it. It may not be every police department in Montgomery County. They don't all have it. There may be one or two that have information. It's not that difficult in most cases to identify that. Then you begin to build a culture where it's automatic, right? Where it becomes part of the process. And I think until we do that, we really won't have it. Easy to make some adjustments in the other doctrines. There's no reason why absolute immunity ought to apply when somebody does this deliberately, intentionally. We have a doctrine of qualified immunity, which protects good faith actions of government officials. That's a broad enough immunity. It doesn't have to be that. Bar associations have to take this more seriously. And prosecutors who talk about this problem and say, yes, we really do it right, have to take action against fellow prosecutors in their office. When there's a report of it, they've got to investigate seriously, and they've got to take internal disciplinary action of some kind. If all those things came together, in 5 years, we wouldn't be here at another panel on Brady. Would the problem exist? Absolutely. Would we still have problems? Absolutely. We'll never reduce it completely to zero, but we can eliminate a lot of what we do now if both the courts, institutions like bar associations, and prosecutors' offices took this more seriously.